Xin chào quý vị và các bạn. Chào mừng quý vị các bạn đến với chương trình bình luận án lệ nước ngoài. Hôm nay chúng ta xem một cái án lệ của tòa tối cao Canada. Cái vụ này có tên là Robinson vào năm 2013. Thì xem thì coi là cái việc quy định xác định yếu tố substantial part của một tác phẩm như thế nào. Và sau đây chúng ta sẽ xem cái phần bản án. The trial lasts for 83 days and resulted in the production of voluminous evidentiary reports after considering the testimony of over 40 witnesses and experts. We go into examine the principle of substantial part. Như vậy thì cái hành vi mà sử dụng cái phần quan trọng tác phẩm thì được thể hiện như thế nào. The general stop of incident in fiction or drama is free for all to use. The substantial part of everyone's culture, not of any one individual work. Như vậy thì chúng ta thấy rằng substantial part. However, the act does not protect every particle of an original work. Any little pieces of taking of which cannot affect the value of the work as a whole. Section 3 of the Copyright Act provides that the copy owner has the sole right to reproduce the work or any substantial part thereof. The substantial part of a work is flexible notion. It is matter of fact and degree. Whether a part is substantial must be decided by its quality rather than its quantity. So we can see that in the copyright law, they just protect content, they not protect quality inside of the work. But you can see that a substantial part very important in this case. And what constitutes substantial part is determined in relation to the originality of the work. That's warrant the protection of the Copyright Act. And the general proportion, a substantial part of the work is a part of the work that represents a substantial portion of the author's skill and judgment expressed therein. Như vậy thì mặc dù cái quyền tác giả không có quy định về cái phần nào là cái phần quan trọng, phần trọng yếu của tác phẩm, nhưng mà các bạn sẽ thấy là trong những cái án lệ thì họ cũng đã đề cập cái substantial part như là một cái chất lượng của sản phẩm. Đó. Và cái phần này là một phần thể hiện cái skill, thể hiện cái originality of the work, cái tính nguyên gốc của cái tác phẩm này. Như vậy thì substantial part, như vậy thì một trong những cái nội dung để bảo hộ quyền tác giả, chúng ta thấy là không những là bảo hộ hình thức, chúng ta thấy là bây giờ họ xem xét thêm những cái nội dung về cái tính originality of the work. A substantial part of a work is not limited to the word on a page or the brush stroke on a canvas. The Act protects author against both literal and non-literal copying, so long as the copy material form a substantial part of the infringed work, as how law put it. The part which is regarded as substantial can be a feature or combination of feature of work abstracted from it rather than forming a discrete part. The original element of this plot of a play of novel may be a substantial part, so that copyright may be infringed by a work which does not reproduce a single sentence of the original. So the need to strike an appropriate balance between giving protection to skill and judgment exercised by author in the expression of their ideas on the one hand, and leaving idea and elements from the public free for all to draw upon on the other, form and background against which the argument of the party must be considered. So very complicated in this issue. An issue of appeal, the Cinar appellant no longer contest the trial judgment, finding that Robinson's work as a whole was original, that several other appellants had successful work, and thus Sucroë and curiosity set a common feature. Rather, they argue that the trial judge made several errors in his assessment of whether a substantial part of curiosity is reproduced in Sucroë, giving rise to remedy for copyright infringement. The conclusion of trial judge that a substantial part of plaintiff work was copied is entitled to appellate deference. The issue of substantiability is one mixed fact and law. Consequently, an appellate court should generally defer to trial judge finding on substantiality, unless the findings are based on an error of law or palpable and overriding error of fact. So it's very complicated to see what is can conclude a substantial part. So the question is, did the trial error in finding that substantial part of Robinson's work were reproduced in Sucroë? The trial judge upheld by the Court of Appeal found that the Cinar appellant infringed Robinson's copyright by copying a substantial part of his original work without his or medium authorization. The Cinar appellant contend that the trial judge failed to follow the correct approach to assessing substantiality, failed to give sufficient weight to the significant differences between Sucroë and curiosity, make an error of finding that the feature of curiosity reproduced in Sucroë were protected by the Copyright Act, and base its finding on inadmissible expert evidence. I will address each of these arguments in turn. Did the trial fail to follow the correct approach to assessing whether a substantial part of the work were reproduced? The trial found that the Cinar appellant copied a number of features from Robinson's curiosity, including the visual appearance of the main protagonist, the personality trait of the main protagonist, and of other characters, visual aspect of the setting, and recurring scenographic element. He concluded that, considered as a whole, the copy feature constituted a substantial part of Robinson's work, and we can see here the Cinar appellant argued that instead of applying a holistic approach, the trial judge should have applied the three-step approach requiring him to determine what element of curiosity were original within the meaning of the Copyright Act, exclude non-protectable feature of Robinson's work, such as idea element drawn from the public domain and generic element commonplace in children's television show, and compare what remained of curiosity after this wearing out process to Sucroë, and determine where a substantial part of curiosity was reproduced. So the approach proposed by the Cinar appellant is similar to the abstraction filtration comparison, Approaches used to access substantiality in the context of computer software infringement of the unity state. And then just say, I do not exclude the possibility that such approach might be useful in deciding whether a substantial part of some work, for example, computer programs, has been copied. But many types of work do not lend themselves to reductive analysis. Canadian courts have generally adopted a qualitative and holistic approach to assessing substantiality. The character of the work we will look at. The court will, in all cases, look not at isolated passages, but at the true work as a whole to see whether the use by the defendant has unduly interfered with plaintiff's right. So you can see here they use the 3 tabs in order to see what is a substantial part. And as a general matter, it's important to not conduct the substantiality analysis by dealing with copy feature piecemeal. Besides view, the approach proposed by the Cinar appellant risks dissecting Robinson work into the component part. The abstraction of Robinson work to the sense of make it original and exclusion of non-protectable element at the outset of the analysis would prevent a truly holistic assessment. This approach focuses unduly on whether each of the parts of Robinson work is individually original and protected by copyright law, rather the cumulative effect of feature copy from work must be considered to determine whether those features amount to a substantial part of Robinson's skills and judgment expressed in his work as a whole. So, the question of whether there has been substantial copying focuses on whether the copy feature constitutes a substantial part of the plaintiff's work, not whether they amount to substantial part of the defendant's work. The alteration of copy feature of their integration into a work that is notably different from the plaintiff's work does not necessarily preclude a claim that a substantial part of a work has been copied. As the Copyright Act stated, infringement includes any colorable imitation of a work. Definition of infringing. So this is not to say that differences are irrelevant to the substantiality analysis if the differences are so great to that work, viewed as a whole is not an imitation but rather a new and original work, then there is no infringement. And the Court of Appeal put it, the differences may have no impact if the borrowing remains substantially. Conversely, the result may be also novel and original work simply inspired by the first. Everything is therefore a matter of nuance, degree, and context. So he concluded that despite of any differences between the work, it was still possible to identify in Sucroë feature copied from curiosity, and thus the feature constituted a substantial part of Robinson's work. The trial judge did not err in approaching the matter in this way. And the Cinar appellant contend that by failing to follow the 3-step approach and to give such sufficient weight to differences between the work, the trial judge characterized as a substantial part of the work a series of features that are not protected by copyright law. They argue that at most, Sucroë reproduced the idea embodied in curiosity, Elements drawn from the public domain, such as the protagonist of Daniel for nearly 300 years old novel and all the elements that are not original within the meaning of copyright act. And then he should say, je vais d'abord examiner l'argument selon lequel Sucroë n'est que la reproduction de l'idée d'une série télévisée pour enfants portant sur un personnage inspiré de Robinson Crusoe, qui habite sur une île tropicale, plutôt que l'expression de cette idée par Robinson. Je ne peux retenir cet argument. Le juge, au premier instant, a clairement fondé sa conclusion selon laquelle une partie importante avait été reproduite non pas sur l'idée, sur ton curiosité, mais sur la façon dont M. Robinson a exprimé cette idée. Il a affirmé que la structure de base du projet de série télévisée de M. Robinson avait été reprise. Il y a aussi conclu que la représentation graphique de plusieurs traits de personnalité du personnage principal de curiosité avait été reprise, qui n'ont été de même de la personnalité des personnages secondaires qui gravitent autour du protagoniste, donc curiosité, et que la présentation graphique du village où habitent ces personnages avait pour sa part été reprise en partie. Ces conclusions ne se limitent pas à la reproduction d'une idée abstraite. Elles mettent l'accent sur l'expression détaillée des idées de M. Robinson. And then the court say the development of group of characters that have specific personality traits and whose interaction hinge on those personality can require an exercise of skill and judgment sufficient to satisfy the Copyright Act originally criterion. You can see example for reproduction avant Cinar video. Sucroë reproduce more than a generic element, which you are free to draw upon for inspiration. This reproduce curiosity, particular combination of character with distinct personality trait living together and interacting on tropical island, element that represent substantial part of skill and judgment expressed in curiosity. So it's very, very complicated, this issue. We're going to see another idea. En fait, les appellants Cinar contestent essentiellement des conclusions mixtes de fait de droit que le juge de premier instant a tiré dans ses motifs. Il invite la Cour à procéder à une nouvelle évaluation des caractéristiques reproduites de curiosité. Je décline cette invitation. Les appellants Cinar n'ont pas trouvé que les conclusions du juge de premier instant relatives à l'importance de la partie reproduite de l'œuvre sont entachées d'erreurs manifestes ou dominantes. The Cinar appellant argued that the trial judge based the bulk of his finding regarding substantial copying on inadmissible expert evidence. The evidence of semiologist Dr. Chad Ferraton, semiology is the study of sign and symbol and how they convey meaning. Dr. Ferraton offered evidence that, quite apart from the surface meaning of the work at issue, there were latent similarity in how the two works use atmosphere dynamic, motive, symbol, and the structure to convey meaning. The trial judge relied on this evidence in concluding part that the Cinar appellant has copied a substantial part of Robinson's work. So, problems. This appellant Cinar soutient qu'en l'espèce, il n'a pas été satisfait au deuxième critère, la nécessité de la preuve, selon que la preuve d'espèce n'était pas nécessaire pour aider la Cour parce que la question de savoir si une partie importante d'une œuvre a été reproduite doit être évaluée du point de vue du profond faisant partie de l'auditoire visé par les œuvres en question. Ils affirment que le juge de première instance est bien placé pour comprendre le point de vue de thème profond et qui n'a pas besoin de l'être, de l'expert, de bien saisir ce point de vue. In my view, the perspective of a lay person in the intended audience for the work at issue is a useful one. It had a merit copying the analysis of similarity, rich and grounded in work themselves, rather than in esoteric history about work. However, the question on why remains whether a substantial part of plaintiff work was copied, this question should be answered from the perspective of a person whose senses and knowledge allow him or her to fully access and appreciate all relevant aspects, pattern, and letter of the work at issue. In some cases, may be necessary to go beyond the perspective of a lay person in the intended audience for the work and to call upon an expert to place the trial judge in the shoe of someone reasonable versed in the relevant art of technology. So, see here another idea. À titre d'exemple, deux œuvres de musique classique peuvent sembler différentes pour un profane. Peut-être parce qu'on le joue avec des instruments différents ou à un rythme différent. Cependant, un musicien averti pourrait entendre des similitudes donnant à penser qu'une partie importante de l'œuvre originale était reproduite. La même armature de clef, le même arrangement de notes dans les passages récurrents ou un accord harmonique récurrent et inhabituel. Certes, il reviendra au juge de déterminer si les similitudes permettent de conclure qu'une partie importante de l'œuvre originale était reproduite. Cependant, pour trancher cette question, il pourrait devoir examiner non seulement la façon dont les œuvres sonnent à l'oreille d'un profane faisant partie de l'autorité visée, mais aussi les similitudes structurales que seul un expert peut déceler. So problems will become bigger and bigger. In the present case, the necessary criterion of the test of the admissibility of expert evidence is satisfied. First, the work at issue are intended for an audience of young children. A rigid application of the lay person in the intended audience standard won't unduly restrict the court liability to answer the central question, namely whether a substantial part of Robinson's work was copied. This would shift the question to whether the copy features are apparent to 5 years old. So, some résumé. Les appellants Cinar n'ont pas réussi à démontrer que le juge de première instance avait commis une erreur en concluant qu'il n'avait reproduit une partie importante de l'œuvre de Robinson. So, we see that the Cinar appellant have failed to establish that the trial just erred to conclude that the copy substantial work Robinson. And here, finally, Robinson argued that David is liable as a producer of Sucroë. His name appears as translation, executive reproducer, and sold credits in Canada and a producteur délégué in France. This alone is insufficient to hold David personally liable. As executive producer, he was acting officer of France Animation, received French animation, and a corporate entity distinct from its director and officer, that reproduce a substantial part Robinson work by commission and commercialized Sucroë. And the court of appeal corrected noted various contract established that it is one animation and its co-producer, Cinar and Ron Prosper, who hired the production staff and assumed financial as well as artistic responsibility for production of Sucroë. That is the question. So, what is the method? À mon avis, la Cour d'appel a commis une erreur en modifiant la conclusion du juge de première instance, selon laquelle il est impossible de dissocier le profit provenant de la trame sonore de se tirer du matériel violent, le droit d'auteur. La méthode du profit différentiel retenue par la Cour d'appel est généralement utilisée dans les affaires de la contrefaçon, permet à son auteur de commercialiser des produits d'une façon plus rentable qu'il n'aurait pu le faire sans la contrefaçon. Cependant, rien n'indique que la trame sonore aurait pu être commercialisée de façon distincte si la curiosité n'avait pas été contrefaite au départ. La trame sonore a été commercialisée seulement à titre de composant de l'émission de télévision Sucroë, qui est elle-même une reproduction de partie importante de l'œuvre créée par Robinson. Le juge de première instance était en droit de conclure que la trame sonore n'avait aucune valeur en soi et qu'elle a généré de profit seulement à titre d'accessoire de l'émission de télévision. Par conséquent, il n'a pas commis une erreur susceptible de révision en concluant qu'il était inopportune de répartir le profit attribuable à la trame sonore en considérant ceci comme une composante de l'œuvre ne violant pas le droit d'auteur. So, on the other hand, Whisper, Charles, and Eaton have already been found liable to Robinson for substantial amount of money. At the Court of Appeal note, if we be largely deprived of any benefit, they may gain from the infringement. So, a good award 500,000 in punitive damages. The amount 1 million awarded by the trial judge is too high. This was awarded on the basis of the relevant factor and does not give sufficient weight to a substantial amount awarded under other head of damages. On the other hand, the amount of 250,000 awarded by the Court of Appeal failed to fully reflect the gravity of conduct and the need to deter others from engaging in a similar conduct. So, a difference of payment. So, what is the conclusion? Je conclus que le droit d'auteur relatif à curiosité a été violé. Le juge de première instance n'a commis aucune erreur susceptible de révision en conclusion que Sucroë était une reproduction d'une partie importante de curiosité. Les appellants Cinar plaint à tort en faveur d'une approche qui dissecte l'œuvre de Robinson en ses éléments constitutifs. Il faut plutôt adopter une approche qualitative et globale. J'aime ça. C'est très important de voir de manière qualitative. Pour déterminer si une partie importante de l'œuvre de Robinson a été reproduite, les caractéristiques reprises par les appellants Cinar doivent être examinées cumulativement en tenant compte de l'œuvre de Robinson dans son ensemble. C'est justement l'approche qu'a adopté le juge de première instance De plus, la preuve d'expert sur laquelle il s'est fondé dans son analyse était admissible. Donc, on va venir à la fin. So that's the case of Robinson. Thank you for your attention. We take to report for Intellectual Property, 14 October 2021. Thank you.